Okay, thank you for joining me for this webinar. We're going to be talking about pre-employment screenings for 2021, more specifically the three topics that are listed at on the screen right now, starting with criminal history reform and background screening, and then moving on to the legalization of marijuana and how that affects drug testing, and then we'll be ending with COVID vaccinations in the workplace. My name is Sherry Tischer. I'm with TCI Business Capital. We are a division of Fidelity Bank in Minnesota. Since '94, we have been providing funding to support growth of businesses nationwide. For our staffing clients, we offer some additional HR and back office solutions. I lead TCI's national staffing practice. I love being an industry partner, but prior to joining TCI, I spent 15 years working directly in the staffing industry in various sales and operations and leadership roles. One of our initiatives at TCI is to be a resource and share educational updates with our staffing clients, which is why we've partnered with other industry experts to provide these webinars. TCI, as well as those joining me today, are all proud members of ASA and or other various state and local staffing chapters. We all have specific staffing practices within our organizations and have expertise and a passion for this industry. Alan Lasky is the Senior Vice President of Sales for Universal Background Screening. They are a top nationally accredited firm, and he has been in the background screening industry for over 20 years. Judy Praska is franchise president and owner of Fastest Labs in Bloomington. Fastest Labs is a national drug, alcohol, and DNA testing company with 55 franchise locations nationwide. And then finally, we have Chris Letty, attorney with Becker Legal. And actually, this is like a stacked benefit here because Chris not only is an attorney with Becker Legal, but he's a former in-house counsel for a staffing company. So Chris has significant expertise providing counsel on a wide range of issues unique to the staffing industry. Before jumping into the presentation, just a couple of quick notes. Go ahead and enter any comments and questions that you have into the Q&A, and we will either answer those questions throughout the webinar or we will address those at the end of the session. This webinar is being recorded, so within 1 to 2 business days, we will be sure and send out an email to each of you attending with a link so you will have access to the slide deck and to the recording of the webinar. With that, let's go ahead and dig in to our first topic, and I'm going to go ahead here and hand this over to Alan. Just give me 1 second. And you know what, Alan, it is not letting me. Did we lose Alan? Huh. Well, this is crazy. I think we lost Alan. Judy, do you see? We might want to give him a minute to log back in.
I don't see him.
Yeah, that something happened and we lost him there. So let's give him just a second to log back in. And what we'll do, if he can't get logged back in here in just a minute, we'll fast forward, Judy, and
Sure.
we'll just do it in reverse. We'll have to flip through a number of slides to get to your presentation, but we'll do that and then we can go back to Alan's if he doesn't get logged back in, but we'll give him, oh,
There he is.
there he is. Hi, Alan.
Hi, sorry about that. I got kicked out.
Yeah, yep, you are back in. So let me give you control of the screen and I'll let you take it from here.
Yeah, sorry about that, everybody.
Yep, nope.
So today we're going to talk about, just for the next 15 minutes, about how to reduce hiring risk, especially pertaining to staffing. And so I'm going to talk first about the trends that we see litigation-wise, and then go into how to reduce hiring risk. And, you know, I thought it would be important to start off with who we report to, because it's really important for the legal portion of it, understanding that. And so we report to the Federal Trade Commission. That's who regulates us. And in 2010, they started the Consumer Financial Protection Bureau to be more specific of the regulatory agency that guides us and also reviews policies and procedures and also regulates. In addition, there's also the EEOC that also regulates our industry as well. And those are important for what we're going to talk about right now. The federal law that we're under as a consumer reporting agency is called the FCRA, the Fair Credit Reporting Act. And it was started in 1970 by Congress. And why that's important to you is that as a federal law, whenever you're using a consumer reporting agency, or even in certain states, if you're doing the background screening yourself, this law you're under as well is designed to ensure accurate information is reported. It also restricts certain information, and it provides a dispute mechanism for consumers to make sure that information is correct. And we'll talk about adverse action, which is the process you have to go through if there's negative information on a report, you're not going to hire potentially that person. It's also important to look at the risk of the industry as a trend. Going back even past 2010, there wasn't that much litigation in our industry. And over the last 10 plus years, it has grown significantly, as you can see on that chart, which is just the federal litigation that goes on in our industry. The Consumer Financial Protection Bureau that I just talked about also has a website. And when you have these slides after we finish the presentation today, you have a link here that is a useful link to show you all of the complaints, which are about 2 million complaints now that are reported to the government. So you can type in any consumer reporting agency's name to see how many complaints they have and to understand as a consumer and as a client of theirs, how many complaints they do have as a resource from the government. But we do see this number increasing dramatically. And so then the question is why is there so much risk and why is there so much litigation? And a lot of it is due to the fact that a third of the US population has some type of criminal record, and laws are now more fragmented than ever before, as we see from a litigation standpoint. There's not just state and federal laws, there's also municipal laws, quite a bit. And we'll talk about ban the box in a second, which relates to that. In addition, we see settlements by private law firms and public and government regulations up to 1.8 million on average. A lot of it is due to the fact also, as you see on the little graphic, that a lot of the media helps consumers understand their rights. So if someone has a case, they're going to watch very carefully that the proper procedures are taking place. And if they're not, they're going to sue, and it usually becomes a class action. It's also important to know that, a lot of questions that we get as a consumer reporting agency is, well, can't I just go online and do a background check on someone? And the answer is, you got to be careful about who you use. You always want to use an accredited agency with the National Association of Professional Background Screeners, which is now called PBSA. And here's a perfect example of one website where if you went online and typed in online background check and you try to do an online background check, if you look at the bottom of those websites, you'll notice that it says it's not for consumer reporting, as you see highlighted there. A lot of them have gotten in trouble in the millions of dollars due to the fact that they're not following proper procedures. You can't just go online and do a background check. So that's really important to always use a federally approved or an association approved background screening firm. One of the biggest areas of litigation we see, which I'm sure you're familiar with, is ban the box. The question, have you ever been convicted of a felony or misdemeanor? This is a very common area of litigation now. There's over 150 municipalities in 36 states, which changes on a monthly basis of more being added about when you can ask that question. There's some references here that we're leaving you with that you can click on to actually see the updates in the laws and regulations state by state and municipality by municipality to make sure that you're following proper procedures in your state or the states you're in. Especially staffing with having clients, you want to make sure that all of these laws and regulations are followed of when you can ask that question. The majority of the laws that we find are after a conditional job offer is made. You can find out more information about a felony or misdemeanor that the candidate has. In addition, another area of litigation that we see is about asking about salary verifications. Now, years ago, that was fine to ask, but as you see here, there's quite a few states and municipalities that are starting their own laws. We do believe it's a trend, and we see that it's in the Ninth Circuit Court still, of having a federal law about restricting the ability to ask about a salary verification for equal pay. There's also two cases that are now case law back in 2018 and 2019, where there were settlements based on the fact of equal pay and salary verifications being asked for, which was in violation of those states. So there is case law now about that. So you'd always want to talk to your legal if you are collecting salary verification information. Now we want to get more into how to reduce risk and through a couple of the areas that are very easy and immediate to reduce risk on. Back in 2012, the EEOC came out with what they called guidance factors, which are really restrictions that are in a lot of the laws and provisions and statutes we see in other laws. And if you follow these are really the golden rules of following whenever you have a candidate. You would always want to make sure you look at the nature and gravity. Is it job related if there's a case? What's the severity of the offense? When did it occur? And is the person a repeat offender? And not to use any blanket policies. So don't put in an ad, we don't hire you if you have a felony or 2 misdemeanors. Even if you have a policy on how you operate based on reducing risk, if someone does have a case, you want to be careful about using any blanket rules. In addition, you just want to speak with your legal about having a program in place that you have in your policy. Look at each individual as a case-by-case basis, even if you have a standardized program and package, and just make sure that everyone's trained that is doing the hiring for the way that you do background screening. And as we just mentioned about standardization, you'd want to make sure that you have consistency in any job or position you're hiring to do it the same way for each individual of that job. So, best way is to create a package for each job position or for the organization, and then to define why you're doing those different services of what you want to catch, which is really important. So you'd always want to speak with your legal and keep it consistent, which is really important. I want to talk about just a few forms, which are the most important forms to know about. This is where a lot of times when we go over with clients, if they're doing this properly, we find out that when they do come over to us, their previous background screening firm didn't go over this. The first is the disclosure and authorization form. So anytime you're going to have a new hire that you're going to do a background check, you have to make sure that they sign prior to any background check, the disclosure and the authorization form. What's important to know is that there should be no extraneous language. So your background screening firm should give you those forms with the proper state and federal language with no additional language. A lot of times a organization will add an indemnification, which is not to what the government wants. It's a requirement not to do that, and it ends up in a class action. So again, it should only have the language that's needed. And also it should be signed, like I said, prior, and the disclosure and the authorization form should be solely by themselves of a disclosure and then an authorization form separate, even if it's electronic, meaning don't bleed it into your application, don't staple it to the application. It's because the government wants to make sure that the candidate is not confused in what they're signing, what they're looking at. So you'd always want to talk about that to your background screening firm to make sure the proper language is there. You see in green the cases in the millions of dollars based on those organizations that didn't do that properly. And again, so best practice would be use a compliant and separate disclosure and authorization form, keep it purely of the legal language with no extraneous language. And again, just speak with your legal about it. The second form that's important to also provide a candidate is their summary of rights document. So this has changed a few times over the years, but it's a simple form that your background screening company should provide you. And it is solely of the rights document for the candidate to understand if they have identity theft or where to go if there's a credit issue or credit freeze, so they understand their rights. And it has to be given to them at some point if a verification is provided to them, you're doing a verification on them, or if you're taking adverse action that we'll talk about in a second. It's just conservatively a good point to give it to them up front so you know they have their summary of rights, which again, your background screening company can provide you, whether it's electronic or they give you the paper form for that to give to the candidate. And last but not least is the adverse action process paperwork too. So this is a form that is provided to the candidate if you're not going to potentially hire them based on negative information on a report, in whole or in part. So if any way you're influenced by that background check, the law is you have to give the candidate a right to dispute that information because it could be incorrect. So the end user has to give it to that candidate, meaning that that's your organization. And what's nice about staffing firms is that you may not be hiring them for one job, but you may be hiring for another client. So they're still, in a sense, hireable. With a company that's just purely not going to hire someone, they have to go through this adverse action process if in any way they've been influenced by the background check. So it gives the opportunity to the consumer to dispute that information. Again, courts are imperfect, so it may be incorrect and false positive information, which is why this process is set up. There are 4 easy steps, and again, you'll have these slides to go through, but these are extremely important steps to always follow if you're not going to hire someone. So you'd want to notify the candidate with an adverse action letter. Your background screening firm should have these letters, so they can provide them to you, or they can do it on behalf of you to provide this letter and send them out. They should also give a copy of the report, of the candidate's report, and the summary of rights document that we talked about. All 3 of those items should be sent to the candidate, and then you have to wait a reasonable amount of time for them to respond, which is anywhere from 5 to 10 business days. Since it's been tried by law earlier and it's ended up in court, 5 to 10 business days is accepted by the government. After that, if they don't respond within those 5 or 10 business days, you would then do the final process, which is sending out the final notice that your background screening firm can provide you, a copy of their consumer rights, the summary of rights document, and a copy of the report. Then you can rescind the offer. So those steps are extremely important to do if, again, at any time you're not going to hire someone, because they have to be given the fair right to dispute the information if they don't feel it was them. I've seen, for instance, a twin use their twin's information, so they disputed it and it was taken off their record because it was their twin that used their information. So that's why that process is set up. And if there is a dispute, your background screening firm should get in touch with you and the candidate to resolve that dispute within a reasonable amount of time. Now, the government says 30 days. Now, we know you can't keep a requisition open for 30 days. Your background screening firm should really finish that within 5 days or less on average. But by law, it has to be left open for that candidate to dispute and then to solve that dispute. And then you can move forward after that dispute is solved. And again, your background screening firm should communicate to you if there is a dispute. With staffing firms, again, it is different because you may be hiring them for another position or another client, so they're still hireable, which is a little different than an organization that is just saying, flat out, no, we're not hiring you and we're going to put you through the service process. So I'm not sure if there are any questions that we'll take now or at the end, but I know we're going to be moving on to drug testing now, so thank you very much.
Mm-hmm. Alan, I do think that there is a question here. Let me pull it up. I have to get through that first part, but would love to hear your guidance on whether or not background checks can or should be performed on direct hire referrals where no employment relationship exists.
So if there's no employment, if it's a subcontractor or a 1099 person, then you can still conduct background screening. If it's for a placement in another organization, that organization actually should conduct the background check themselves, or at least sign some type of affidavit with you as a separate form to say that you have access and they have access. So there's authorization for both of you to see that information. Because that ends up, again, if that isn't followed. There's also something called you also have a situation with a membership or a volunteer or student where we still can do background screening. It's just not for employment. And we would, again, the disclosure form and the authorization form would notify of what that intent is for.
Okay. Yeah, when I worked for Kelly Services, we had a straight up policy if we were doing a direct hire that our client company had to do
That's safe, right. And that's the safest way, just because of the fact that the end user is the organization that's making the influential decision to hire or not hire them.
Yeah.
And that to come back as a class action, as long as you get authorization from the candidate that they understand who's involved in that hiring decision, even if it's another organization and it's, again, a different document that they're signing, a separate, again, as we talked about, you don't want to change disclosure and authorization form with any extraneous language, additional language. So you'd want to have a different form for them to sign.
Yeah, okay. We do have a couple of other questions, Alan, that I'd like to maybe circle back to
Sure.
at the end. So if you guys, would be patient with that, I do want to at least move on to drug testing for now, but circle back on these. So
Great.
yeah, stay tuned. Okay, so let me move on here to our next topic, which is legalization of marijuana and the impact of drug testing. Judy, I'm going to let you take it from here.
All right. Again, I'm Judy Praska with Fastest Labs of Bloomington. And the 4 areas I'm going to touch on today are in drug testing. Is it essential or not? What's popular amongst the users? What to consider when you're looking for a drug testing company, and COVID-19 and how that relates. So essential or not, workplace safety. Whether an employee is operating a machinery or at a manufacturing plant or driving a forklift or stocking the shelves in a grocery store, being under the influence of drug and alcohol endangers the employee as well those around them. So by conducting drug testing, employers are fostering a safe work environment for their employees and themselves. So deterrence. Workplace testing makes the stakes of drug testing use or alcohol abuse even higher. Thus, employees will be less likely to use drugs if they are threatened with their employment. And a random drug testing program is kind of the key component to this and making truly drug testing effective. According to the Office of Health and Safety Services, ongoing employee drug testing lowers the number of employees who test positive because they know that they could be drug tested. And next we'll go to liability. Employees who are injured on the job or fired of drug-related incidents will not be entitled to compensation or be less likely to file suits against their employer. Again, by testing for employees for drugs, employers are able to protect their company from liability and potentially have lower workers' comp costs and even premiums, in some states that is, and could be saving money in the long run. And then it comes to the big question is, do we really save money if we drug test or do we not? It's a myth that drug testing costs too much. It truly is. The fact is, the direct costs are easily to quantify, but the unseen of cost of having a drug and alcohol program can be and often dramatically higher due to the loss of productivity, increased insurance costs, liability exposure, turnover, and internal conflict. So it's important to understand why you want to do it. All right. So we got to have a little fun because we do drug testing all day long. So I threw in a little trivia here. So in our chat box, I would like you to put in, what do you think is the second most commonly found drug in our drug tests? So take a minute, everybody in your little chat down there, put in what is.
I feel like we should be playing like the Jeopardy music or something.
We should. I mean, we do that all the time for my meetings. Jeopardy for drug testing.
Right, exactly. We could have made this a poll question.
Oh, we could have. That's true.
Okay.
So let's see.
What's the answer?
So the answer is, let's see if anybody got it. Oh, some of them got it. Okay. So I'm going to minimize my little chat so I can see. So obviously the answer is methamphetamines and amphetamines are the most popular, second most popular that is. So the key with methamphetamines and amphetamines is if you use it just once, it only stays in your system for 1 to 4 days, which is crazy. And if you're a heavy user of meth, it stays in your system for only a week, which is interesting. Again, if you're going to take a drug test, you just have to stay off it for a week and go take your test. Again, there's emotional and cognitive and physical problems by taking meth, as we all probably know. There's toxic fumes, there's a health hazard. And 2 million Americans, hang on, we're going to go back one yet.
Okay, sorry.
2 million Americans.
Oh no, hold on a second, Judy. Now I'm just going up.
just arrow back.
Yep. And now it's not letting me go.
Oh, there you go. There you go. So 2 million Americans have used methamphetamines in the past year. And the data revealed there's an upward trend of people ages 26 and older. And again, COVID has been hard on a lot of different people, no matter what your mental state is. So just know, meth is being used. So now we can go to the next one. Okay. So now, what is the most commonly found drug in drug tests? So again, in the chat, let's have everybody put in what they think the most commonly used drug is. Dun, dun, dun. We need that music.
Mm-hmm.
See if people are getting it. All right. And the answer is, drum roll, dun, 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 it is marijuana. So Sherry, you can hit the next slide.
Yep. There we go.
Okay, so marijuana is our most commonly used drug. Most of you probably already know this, But the interesting part about marijuana is it stores in your fat cells. So it can stay into your body, even if you use it just once, it can stay in your fat cells for up to 30 plus days. So we get people that come and say, hey, I was on vacation out in Colorado. I just had a little and I have a pre-employment I have to do. I go, well, how long has it been? Because people Google this all the time. It can stay in your body up to 30 days. And it depends on how you eat, how you exercise, how much fat you have in your body. It all depends on all that. And the other part about marijuana, it's in CBD oils. So buyer beware. People come in and they test positive for us. And they're like, what? I don't smoke it. I go, you don't have to. So if you're using a CBD oil, say they get it at a tobacco store or a gas station, probably not the highest quality CBD oil that you want to use. I have others that have a CBD oil that has no THC in it. Make sure you read that label. They actually did a study on this back here in January, and they tested how many different CBD oil products. Some have THC in them, some do not, some have minor ones. So just buyer beware on that one. And now if you're using marijuana, you're 55% more likely to have industrial accidents, 85% more injuries, and 75% more absenteeism. And the key to all this is, guess what? It's become legalized in more states. That is the interesting part. So we'll move forward. So Sherry, if you can click on the link of where it's legal, the top one, there you go. Hopefully it loads for us. Do you see a map pop up for you, Sherry?
I do.
Can you share that on the screen?
It should be shared.
Because we just see where it is legal.
Okay. Maybe we should just kind of.
We can talk through this because everybody will have the link for this as well.
Okay.
So I have obviously a little map of where it's legal. And this map that you'll have access to is updated monthly from DISA. And it's really important to know which states, how it's legal. You know, is it legalized completely? Is it just medical and decriminalized? Or is it fully illegal? So, whoops, we lost the.
I know. Yep. Sorry, share. I'm having to reshare it, Judy, because
it's okay.
Weird. Yep. Okay. Sorry about this.
That's all right. It's called a webinar and technical glitches in between.
I know, right?
If you actually slide down and hit where I am at, you can actually present from that part.
Yeah, it's just not.
It's locking up.
Yeah.
That's okay. So anyway, we can send the link here for the map of where it's legalized and where it's not. Yeah, keep going, you might be able to find.
Yeah, and I don't know what you guys are seeing right now, but my screen is.
We see your screen. We see the PowerPoint. And you can't hit share up there in the top of the screen.
Yeah, it's not letting me.
Well, I'll just keep kind of talking kind of without, there you go. There's part of my presentation. Yay, you found it. Keep going up a couple more.
Yeah, sorry about this, you guys. I don't know what's happening here, but okay, let's start with this then.
So the screen above it was where it was legal. So again, you'll get a map of where it's legal. You just need to understand if it's fully legalized, if it's medical or not. I mean, in Minnesota, medical and decriminalized is where we're at. But again, at a staffing company, you have to be aware of, does your client want to know if they're using or not, and if they have a medical card? So the key is kind of to find out. I always tell the candidates when they come to us, did you let your employer know first that you have a medical card? Because that's important that they know that, because they can disqualify. Like if they're trying for a DOT federal test, you can't use medical marijuana. That's a no-no because it's not federal law. But again, if you're at a staffing company, you may be able to allow that. So I just tell people to be transparent from my side when I see them in our drug testing area. So the key points that I want you to get from this is make sure you know the laws in your state. That is so imperative. And that's why we have legal teams here. Check with the ones in your state. Know the terms for hiring regards of marijuana and medical marijuana. There's a difference. Make sure as an employer that you know the difference and what that pertains to. Some states, even employers can deny even with a medical card. If you're a drug-free workplace, they can actually deny it. So again, just check with your lawyer, make sure. The next thing is just from my end as being a drug testing center is tailor your tests. We have companies that actually take out THC or marijuana. They don't want to test for it for certain jobs. So we know that they're not going to test for marijuana, which is helpful. Okay. And then there's drug-free workplaces. Check your laws. This is really checking those laws and make sure you know what applies to you. And Americans with Disabilities Act requires tolerance for disabilities. If they are using medical marijuana, you have to have that little bit of tolerance there. And then I asked around with other of our fastest labs here throughout the country, and some of them are in states where marijuana is legal. They said some owners do not test at all since it is legal. And then you get the same answer, a different version. Some owners test because it is legal. So again, you have to do whatever your clients are demanding in that staffing world. Again, tailor your test. That's the biggest thing I can tell you is tailor your test. Figure out what works and what doesn't work. There's a blog. I don't know if you can click on that blog. We might get into trouble if we click on that.
Yeah,
blog
let's
again.
not click on the blog because
No worries. I'll just read a little bit of what the blog says.
That has proven to be problematic, Judy.
Okay. So the blog is from a law firm. And again, it's telling about staffing companies, again, develop policies to address the issues of marijuana and drug use, and have a general policy to create awareness and educate your candidates and employees so they know the landscape, what's applicable to them, and what they need to know. Again, the policy should be communicated regularly to the candidates, the employees, and yes, to your clients as well, so they know what you're going to do. So again, good information to know. And then the third part of the presentation is on just drug testing companies when you're looking for one. Make sure that the company you go with, that the results are easy to read and you can understand them. Sometimes it's a little foggy, like, hey, what does this say? Is it positive or negative, or is it non-negative? Is there a quick turnaround time? Hopefully you can get results quickly. Staffing companies, I work with quite a few of them, they want to have those answers right away. They don't want to wait a couple days. Do they have a web-based application or an online portal? It's helpful when people can go out to their web portal, see the results, and say, oh, John Smith is clear, Jane Smith is good, let's go. It is cost effective. Again, we talked about this earlier about being cost effective. Make sure the company you're going to go with, is it cost effective? Check that out. And sometimes you can negotiate, you can see what they can do. And again, customer service. You want those results. If something is not going as fast as it should, or it got sent up to the lab, you can go back and follow up with and say, hey, what happened here? And hopefully that company is ready to give you answers and able to help you quickly and get that person in or out, whatever it may be. All right, and the last part is, because I know Chris is going to talk about COVID, so I thought it'd be kind of fun to throw a little bit of drug testing stats in with COVID before I throw it to Chris. So if you have a substance abuse disorder, means that people they're 1.5 more times likely to get COVID. If they have an opioid disorder, they're 2.4 times more likely to get COVID. If you have a cocaine disorder, which cocaine usage is actually going down, which is a good thing. Alcohol disorder, you're 1.4 more times to have COVID. Tobacco, 1.3. But the interesting part of the bottom is patients with a lifetime substance abuse diagnosis are also experiencing more severe outcomes from COVID than others, including hospitalization. So 41% would be hospitalized and 9.6 were the death rate, which is kind of scary. So anyway, that is drug testing and legalization of marijuana. It is very prevalent. I'll just say through COVID, there are a lot of people that are using marijuana. We see it every day. So just staffing companies, be aware. It is definitely something that's on the high. It's going up, and then it'll get legalized more and more states as we go.
Wow, thank you, Judy.
You're welcome.
Move on to the final section of our webinar today, which is COVID-19 vaccinations in the workplace. Judy and Alan, if you want to take a minute and look through the Q&A, I know there's a lot going on in there. Maybe see if there are any questions that are relevant to each of your topics that we could talk about at the end of the webinar, but we'll get started with Chris now and vaccinations in the workplace.
Right. Thanks, Sherry, and thanks everyone for attending. So we'll dive right into it. The question is, can employers require employees to be vaccinated against COVID-19? In general, yes, they can. You can adopt a mandatory policy that requires employees to be vaccinated upon entering the workplace. However, with that policy, you also have to accommodate any individuals who have disabilities or sincerely held religious beliefs who decline or refuse the vaccine. Now, the EEOC has come out and said that while mandatory policies are permitted, they prefer voluntary policies. So be aware of their preference in that regard. I think the most prominent question we really get is the requirement of a vaccine a medical examination under the ADA, which triggers the ADA? And the EEOC has come out and said, no, it is not. The administration of the vaccine itself, or by an employer or by a third party with whom the employer contracts, is not a medical examination for purposes of the ADA. And why is this? A medical examination is typically a test or procedure done in a doctor's office that seeks information about an individual's physical or mental health status. Examples of these include vision tests, blood tests, cholesterol testing, x-rays, MRIs, things like that. If the vaccine is administered to an employee by an employer for protection against contracting COVID-19, the employer is not seeking any health information. They're simply providing a service. And therefore, it's not a medical examination under the ADA. Likewise, asking for proof of a vaccination is not a violation of ADA. There's many reasons why an employee may or may not have been vaccinated, which may or may not be disability related. So simply requesting proof is not likely to elicit any pre-screening questions or medical information from the employee. However, to that end, if you start asking questions as to why or why not they received the vaccine, then you're going to be subject to the ADA and a standard that the questions must be job related and consistent with business necessity. If you require them to provide proof, and they do provide proof, you're going to want to warn all employees not to provide any additional medical information. If they do, you're opening yourself up to the ADA, which obviously you don't want to, and then obviously what follows, which is litigation and cost. Next slide, please. So this slide is really the cautionary tale, right? The CDC has come out and stated that healthcare providers should be asking certain questions to make sure that they're administering the vaccine to people who are not going to have an adverse reaction to it, right? So in one regard, they're saying, go ahead and do it, don't ask questions, you're good. But they're also saying you have to ask questions. So if you, as the employer or a third party with whom you contract, ask these type of questions, you're going to be subject to the ADA standards for disability related questions. In order for these questions to be permitted, again, they're going to have to be job related and consistent with business necessity. To meet that standard, you're going to have to show a reasonable belief based on objective evidence that an employee who does not answer the question and therefore doesn't receive the vaccine will pose a direct threat to the safety or health of himself or herself or others. And we'll get into the direct threat in a second. So next slide, please. Oh, you got it. Perfect. Thanks, Sherry.
Yep.
So by contrast, there's two circumstances in which you can avoid the job related and consistent with business necessity requirement. The first is going to be if you offer an all voluntary plan, right? The vaccine itself is voluntary, and the pre-screening questions can be answered in a voluntary nature. So if a person chooses A, not to answer the questions, or B, chooses not to receive the vaccine, that's fine. It's not going to be subject to the ADA, but you can then not retaliate against them or take any adverse action against them for refusing to either answer the questions or have the vaccine. The second circumstance is really the best circumstances, really what every employer who adopts this type of policy should be imposing, is having the vaccine administered by a third party with whom the employer has no relationship with, right? It's telling your employees to go to CVS, to their own doctor. That way, nobody you're contracted with and you're not asking these pre-screening questions, which would trigger the ADA. You just want to keep in mind too, and have your employees keep in mind, that if they receive any kind of medical information, it still has to be kept confidential under the ADA. So keep that in the back of your mind. Anything you receive medically should be put in a separate folder and it should be kept confidential. So the next thing that obviously follows is, what if somebody comes and says, I can't receive the vaccine because I have a disability, right? The ADA does allow a direct threat standard, or in other words, a requirement that an individual shall not pose a direct threat to the health or safety of the individuals in the workplace. However, though, if your policy screens out or tends to screen out people with disabilities, you're going to have to show that an unvaccinated employee would pose a direct threat to a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. And we'll get into reasonable accommodations in a minute. The EOC has gone further and stated that a conclusion that there is a direct threat would necessarily include a determination that an unvaccinated person will expose others to the virus at the work site. So when you're making that determination, they set forth 4 different factors to consider. It's going to be the duration of the risk, the nature and severity of the potential harm, which we all know can be extremely harmful, the likelihood of the potential harm will occur, and the imminence of the potential harm. It's really the last two factors that you're going to look at, and that courts would look at if you had a direct threat. So basically there, what you're going to do is you're going to look at your workforce, you're going to look at your line of business. With regard to your workforce, you might want to look at age, medical conditions that you're aware of. Are they client facing, or are they just working remotely? And then on the other side, you want to look at if they're frontline workers, then obviously that direct threat standard is going to be there because they're constantly interacting with people who could or may be exposed to it. So then after you make that assessment, you have to determine whether that individual who cannot be vaccinated poses a direct threat. The employer can still not exclude them from the workplace unless there is no way to provide a reasonable accommodation to that employee. So you're going to then have to take the step to see if there's any other EEO laws or other federal, state, and local laws that apply that would prevent you from providing an accommodation or not require you to provide an accommodation. Some accommodations that people have seen are working remotely, which I think a lot of us, most of us probably have been working remotely for quite some time, or leave under federal, state, or local law, right? There's state laws that explicitly state that leave is a reasonable accommodation. Now, just keep in mind, leave is not a reasonable accommodation if it's indefinite. There should be a set time period, and case law will help guide you on how long that leave should be. Another example is if the workplace configuration provides ample distance between employees and customers, has excellent ventilation, you're complying with all CDC standards and all OSHA guidance, and there's no record of any outbreaks at the work site, then you're gonna have a problem showing that there was a direct threat. On the other hand, like we talked about, if you have frontline workers, you're at a hospital, it's gonna be much easier to show that there's a direct threat there. Basically, all this is saying is make sure you enter into the interactive process to see if there's any reasonable accommodations that can be made to the person who cannot receive the vaccine due to disability, right? Again, working from home, mask, double mask, testing, social distancing, non-public facing roles, maybe revising their schedules, all things that a lot of states have already passed. So they're kind of doing your job for you that you already have to comply with. But those are things that you want to keep in mind. And that the next question that follows too is, it's in the same regard as disabilities. It's what happens with people who sincerely held religious beliefs who can't receive the vaccine because of that. So once you're on notice that they hold a sincerely held religious belief that prevents them from receiving a vaccine, you have to provide an accommodation unless there's an undue hardship. And courts have defined an undue hardship as having more than a de minimis cost or burden. And so the EEOC goes on to state that because religion is so broad and there's so many different types of religion, that you as the employer should generally assume that their sincerely held belief is sincerely held, unless you have an objective basis for questioning that. And if you do have an objective basis for questioning that, then you can request additional documentation. For example, a letter from clergy related to the objection, right? Saying that it is a truthful statement on their part. So then at the end, if you can't provide an accommodation, then and you have to still exclude them from the workplace and they can't work remotely, then yes, you can take action. However, you want to be very careful on the action you take. It's like we said in the PowerPoint, it is a minefield. And the reason I say that is because there's a thing called temporal proximity, which means the date of the action and the date of the protected activity. So the date of the action being termination and the date that they requested protected activity. If they're close in time, the court's going to find, or at least let them get through a summary judgment motion, and they're going to make you go through discovery, which is going to cost you tens of thousands of dollars. So that is the one drawback here. And then the next one is the Genetic Information Non-Discrimination Act, or otherwise known as GINA. It's basically the same thing that we just covered. This is implicated when an employer administers a vaccine or requires proof of vaccine, or it's not implicated because it doesn't involve the use of genetic information to make employment decisions. However, if you're asking pre-screening questions about maybe family members, about their family members' medical histories, then you're probably going to violate GINA, and you're going to be subject to a lawsuit under that for discrimination. Then we get into legal ramifications. So the first part is the EOC has put out all this guidance, which is great, and we could all use some guidance for sure, but it's not law, meaning courts do look to it for guidance in some circumstances, but they're not bound by it. This is not a law. The courts are still free to choose to interpret laws how they see fit, and they look at it just as that, potentially guidance. So don't hang your hat on the EOC. While it may be a defense, it may not be a great defense. The other, to me, what the biggest issue here is the emergency use authorization versus a fully authorized vaccine. Under the law, the FDA has the obligation to ensure that recipients of the vaccine under an EUA are informed to the extent practical under the applicable circumstances that the FDA has authorized the emergency use of the vaccine of the known and potential benefits and risks, the extent to which, and the extent to which the benefits and risks are known. And this, very importantly, that they have the option to accept or refuse the vaccine and any of the available alternatives to products. So that part, that they have the option to accept or refuse the vaccine under law, gives them a public policy claim and a protected activity. So if you then terminate someone for refusing the vaccine, they could bring a lawsuit based on engaging in a protected activity and you retaliating against them. So I think that's going to be one of the bigger ones that we see coming forward. Then on OSHA, OSHA's kind of a tricky one. OSHA hasn't provided a mandate yet for mandatory vaccinations, but OSHA has indicated that you may institute mandatory vaccine policies. Section 11C of OSHA protects employees who refuse, or may protect employees who refuse a vaccine under the belief that there is a health or safety concern. So basically what 11C says, it prohibits employers from retaliating against employees for exercising a variety of rights guaranteed under the Act, including raising a health and safety concern with their employers. But on the flip side, under Section 5A1, employees can allege that if employers do not have a vaccine program, that they're not providing a safe work environment as required by that section. So it's kind of a double-edged sword. You're kind of damned if you do, damned if you don't. OSHA's also recently issued new guidance for 16 steps to an effective plan to prevent the spread of COVID, which includes making a COVID-19 vaccine or series available at no cost to eligible employees. So basically they're promoting the vaccine. So it'll be interesting to see if lawsuits are filed with this and how these two sections are interpreted and which section actually probably wins. Then you have state laws. State laws in the past year, a lot of legislation has been passed or tried to be passed. For example, in Louisiana, they were trying to exempt employees from vaccine requirements. In Rhode Island, they were trying to prohibit employment discrimination against individuals who did not receive a vaccine. So you really, especially in the staffing industry, since you're all over the country, you have to pay attention to your state's laws where you are located and where you have employees located to make sure that you're compliant and you're not impermissibly putting a vaccine program in one state and permissibly in another state. And then finally, we're just gonna look at the practical considerations, right? The availability of the vaccine is it's not there. I think where I am, there's 2 million people signed up that haven't been called to schedule. So it's just not readily available. So how can you expect your employees to do that, right? Just one consideration. Also, the vaccine itself, we don't know whether it protects the carrier, or if the carrier being the person who was vaccinated, or if that person could still carry the virus and spread it to other people. There's still no data out there, so that's one consideration to have too. Also, you have the public policy that's in place as well. I think 27 to 40% of people polled in December said that they would decline receiving the vaccine. So 27 to 40%, that's obviously going to affect your workforce in some way. Also, if you're requiring the vaccine, you want to keep in mind too that you're going to have wage and hour issues. So if you're requiring someone to go get a vaccine, you're going to have to pay them for that travel time. And there may be workers' comp that flows from, right? If they have some kind of adverse reaction to it, that could fall on your workers' comp. And you want to make sure that your workers' comp carrier is going to protect you against that. And then also finally, or not finally, one more after this, but you're going to have to provide time off to recover. A lot of everybody I've known who's received the vaccine has been down for at least a day. It's usually, I think, 14 to 16 hours after they receive the second dose. They have chills, they have fevers. It's not a pleasant experience for them. So there will have to be some kind of leave provided. And finally, a lot of companies are offering incentives, right? And monetary incentives, which are not, which may or may not be legal. Under the EOC wellness programs, a modest value is allowed. So that's typically a water bottle, they said, or a gift card of modest value. But if the incentive is deemed to coerce an employee into getting the vaccine, then it can be deemed a violation of the ADA. And on the flip side too, if you have somebody who has a disability who can't get the vaccine and then thus can't get the incentive, it could be said that you're discriminating against that person by not providing the incentive. The EOC has been asked for further clarifications on this, and we're still waiting to hear on that. And that's it on mine.
Okay, thank you so much, Chris. We've got between 5 and 10 minutes left. So let's do this. Let's circle back to Alan. And I know you were glancing through some of the questions, and let's go back. And if there are any that you're able to answer right now in a couple of minutes.
Sure, yeah. There are two questions that I saw posted, and I can answer both really quickly. One was about summary of rights document and when you should give that document, and can you give it up front? And the answer is you can give that summary of rights document right up front. The only time that you'd also want to give it is if you're going to be doing that adverse action process. You'd want to give it back again to them for the pre-letter and the final letter. So just as a process, that's what you'd want to do. But absolutely, you can give it right up front as the document, so you know conservatively that they have it already. There's no restriction that you cannot give it earlier, so you can give it when you give the disclosure and the authorization form as a separate form. The other question was about ban the box in Texas. The answer is that Texas state does not have a state law for ban the box, but as we were talking about, of all the municipalities that have laws, there are 4 municipalities, which are Austin, Dallas County, San Antonio, and Travis, that all have laws, but they're all for public sector jobs, not for private. And all of them kind of relate to later in the hiring process or after a conditional job offer is made. San Antonio has to remove the question altogether from the application completely. But again, that's for public jobs. The other thing that was brought up was salary history. Again, we'll provide you information about which states, which is in that slide. And I'm more than happy to answer any questions after about specific salary exemptions in any of the states.
Judy, there were a couple of questions, I think, for you as well.
Yes. So one question was, how do they qualify for a medical card in Minnesota? And actually, if you just go to the Department of Health, I actually Googled it. There's a registration process. So I put the link in the chat for how do you register in Minnesota for a medical card. Again, you have to qualifying conditions, contact your health provider, and then you have to have a visit, and then you can have this health card person has to certify that you are able to get it. And then you have to register online, and then you have to visit a cannabis patient center. So it's pretty self-explanatory if you just Google how to register for a medical marijuana card in Minnesota. That was one. And my second question that someone asked was, what are the pros and cons of removing THC from your drug test in the state where it's still illegal? The pros are actually you'd be able to hire a lot more people. I'm just telling you that from my end. We see a lot of people that fail because of marijuana. The cons are, depending on what type of work they do, if they are in safety sensitive jobs, I would be very careful of what you do, because that could be a huge liability. So again, I just say types of accidents. That's just from my perspective. I'm sure Chris may have another idea too of why you should not do it when it's not legal, when it's legal in your state. But again, staffing companies, have that prerogative to change things if they need to. So hope that helps.
Chris, there are a couple of questions for you in the chat box. One is, can you mandate just a certain group of your employees that they must get vaccinated. For example, a group of my employees have direct contact with our clients. So can I put a policy in place that employees who work on production lines with clients have to be vaccinated when the vaccine becomes available?
Yes, you can. As long as your policy is legitimate, non-discriminatory policy on its face, and that's what this would be, because obviously you're trying to protect your workers who are out there every day, as opposed to people who may just be in the office or working remotely. That would be a legitimate non-discriminatory reason. The only thing that you could say is what's called a disparate impact. So if you have, if those workers are predominantly one race, whereas everybody else who's not being mandated is another race or color, creed, religion, whatever protected characteristic that you may come up with, then overall, even though it may be a facially neutral policy, it could still have a disparate impact and be considered to be discrimination. As long as it's a good mix, then you're fine.
Okay. One other question here for new hires. Will employers be able to pay more for vaccinated employees than a non-vaccinated employee?
Will they be able to pay more?
So I'm guessing like the actual pay rate of, so.
Yeah, and that you're going to get in, you could, but then you're going to get into disability, the whole disability, right? Because then if somebody didn't receive a vaccine because they're disabled, and you're paying someone more because they did receive the vaccine, then people with disability are going to say, whoa, I'm being discriminated against because I couldn't receive the vaccine. So that's your one drawback right there.
Okay. And then one other question. If an employee doesn't want to take a vaccine due to medical reasons, do they have to provide proof of that, or does that open up the company to the ADA?
Yeah, at that point, you're going to be open to the ADA if you're gonna push the issue, because it's just like any other interactive process where you're providing a reasonable accommodation. I mean, some people's disabilities, right off the bat, you really don't need documentation. If it's not as prevalent, you don't know, then asking for documentation is reasonable to support their request for accommodation. But again, it's all going to come down to the interactive process, knowing what can and cannot be done. And typically, in circumstances like these, you're going to want the doctor's input anyway, or the healthcare provider's input to see what kind of accommodation can be made to allow the person to perform the essential functions of his or her job.
Okay, thank you so much. That appears to be all of the questions. So, and we are, I think, coming right up on the hour. So thank you everybody for joining, and for the presenters. I have slides of each of our contact information here that I will include at the very end of the deck. So when you guys get a recording of the video, you'll have this slide deck as well. Stay warm, stay safe. Have a great 2021. Thanks for joining.
Thank you.
Thank you.